Yes, Your Honor. I'm sorry. Good morning.
Good morning. Who's your client?
Mr. Jordan Robbins.
All right, Jordan Robbins, come forward. Could I see the file on Jordan Robbins, please? All right, we're going to go on the record. Court is calling 2022 CR 11724, State of Texas versus Jordan Luke Robbins. Can I have parties announced for the record for the state?
Kelly Jackson.
For the defense?
John Floyd for Mr. Robbins.
All right, any objection to defense counsel being by Zoom?
No, Your Honor.
And are you Mr. Robbins?
Yes, ma'am.
All right, defense has filed a motion for continuance. Defense?
Yes, Your Honor. Yes, Your Honor. We joined this case in early June. We've made our way through the discovery, and during that time, we realized that there had not been a independent investigation from previous counsel, and so we have engaged an investigator who's been working on catching up, who's also gone through all the discovery and is out interviewing witnesses and kind of advancing our investigation. In addition to that, I think more pressing is that we have a trial scheduled the same day as this one is scheduled in Bell County. It's a sex assault of a child case that is from June of 2019. It's number one up on the docket, and the court has instructed us it intends to go on that case. And so we're asking for a continuance to set this case for a date that we can be available and we can have our investigation completed.
Okay, so let me just give you a little history with this case.
Yes, Judge.
On February 3rd, 2023, there was a discovery for electronic devices. And then it was reset for March 7th, 2023. There were more discovery issues. Then it was reset for April 25th, 2023 for more discovery issues. Then it's reset for May 25th, 2023, and that had to do with discovery issues, therapist records, a SANE video, and the cell phone doc. Then it was reset for July 13th, 2023. There are different discovery items that had been provided. Then it was recalled for August 15th. There was a motion to release the medical records. And then it was set for jury trial on September 18th, 2023. Then it was recalled on September 20th, 2023 for the state to tender an offer for your client, who wasn't your client at that time. He had retained other counsel to appear by Zoom. Then it was reset for September 25th for a ruling on the medical records. Then it was reset for December 11th, 2023 for more discovery. Then it was recalled back on January 30th, 2024 to make sure everybody had their discovery. And then it was recalled for February 20th, 2024. An offer was due, and that was going to be the last date for discovery. And then all of the discovery was stated to the court on February 20th that it was received. It had been uploaded. And there was a plea deadline date of March 11th, 2024. And then it was reset for April 9th, 2024. Then it was recalled for jury trial on June 4th, 2024. There was a reset given to defense counsel because the defense said they had a witness that was out of state. And so a motion for continuance was granted. And then after that is reset for September 9th, 2024. This case has been going on since 2023. I always tell people when they are retained on cases, they need to realize where this case has been. Motion for continuance is denied. You're going to be an impact on September 9th. So you all need to be here.
All right. Thank you, Your Honor.
All right. Thank you. Thank you. Nathaniel Vasquez.
Present, Your Honor.
All right, Mr. Vasquez, if you'll come forward. Hello, how are you doing?
Yes.
It's a lovely day, Judge.
Yes. All right, we have a violation report. Your client missed a setting, well, an appointment with pretrial services.
Yes, Your Honor. I tried to contact him.
Everyone, will you all please whisper? But if you're not going to whisper, bring that same level of tone when you're before the bench so I can hear you. Yes.
I finally was, the numbers that we had, that the pretrial had was his mother's telephone number. She works, I was able to call early enough yesterday that I finally got a hold of her. Apparently, Mr. Vasquez was not staying at the home. Are you staying somewhere else?
No, yes, sir.
Yes. So I don't know if she didn't understand who the numbers were. He's been reporting to his bonds person. Nobody ever told him, Your Honor, I would ask that he be allowed to go now that he understands he has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for one, your own case, as far as showing up. Just, I don't know why. And when I was a defense attorney too, people would say, well, my bondsman never told me. Well, your bondsman will not be going to jail if you don't show up. Do you understand?
Yes.
So with this pretrial services, you need to be in contact with them. Do you understand?
Yes.
All right, just have a seat. Ms. Ferguson, can you have his pretrial services officer zoom in? We're going to have his officer zoom in so they can have all of your contact information. Do you understand?
Yes, ma'am.
All right, so just have a seat.
May I be excused, Your Honor?
Yes.
Thank you. You don't need me for that.
Jabbar, sorry, Chaz Jabbar Reed. Good morning, Mr. Reed. All right, so where are we on discovery?
So I need to double check. I don't think we have one of the underlying
Cases?
cases that we need to search.
Indeed. Well, and then also, there may be a record that I'm looking for where he signs.
Yes.
And
I'm double checking some discovery for Dr. Tom.
All right, how long are y'all asking for discovery?
2 weeks.
All right, Ms. Ferguson, can I have a 2-week reset on Chaz Reed, please?
how you doing today, Judge?
Oh, I'm doing okay. It's Friday Eve. How can you not be happy?
Feel like it's Friday.
Today, he's very excited.
Yeah. What time? September 12th. All right, so we'll be back on September 12th.
Okay.
All right, is there anything else?
No, ma'am.
All right, Mr. Reed, do you have any questions?
I was gonna see if I can do anything like apply for a PR bond or something. I got I was out there.
Oh, what I can tell you is number one, you'll have to have a motion set for that. If you want counsel, I can have him interviewed for a PR bond.
It's already been three months. I haven't paid my child support or anything. My ex-wife is asking my mom for money now.
Judge,
I
perhaps you
haven't
can
paid.
have him interviewed today and,
Well, I don't know if it's going to be today, but I'll put
okay.
in the order to request that he be interviewed today.
all right.
So I'll have you interviewed for a PR bond. Counsel, once that's completed, we can bring him back.
Okay.
If it may be completed sooner than the 12th. Okay,
All right.
all right.
Thank you.
Thank you.
Thank you.
All right, is the interpreter here on Wilfredo Salinas?
Good morning, Your Honor. Carlos Ramirez for defense.
All right, court is calling 2022 CR 2397, State of Texas versus Wilfredo Salgado Salinas. Could I have parties announced for the record for the state,
U.S. Crawford, State of Texas.
for the defense?
Carlos Ramirez for defense, Your Honor.
All right, and are you Mr. Salgado? Is it Salgado Salinas?
Salgado Salinas. Salgado Salinas.
All right. And is that you? Are you Salgado Salinas?
Wilfredo Salinas Salgado. Wilfredo Salinas Salgado.
All right, and we have an interpreter present. All right, so you're filing a motion to withdraw?
That is correct, Your Honor.
Why?
So our client is dissatisfied with the services he's received. He's already discontinued payment of the retainer. He's seeking to terminate our services to seek out a new attorney, Your Honor.
So here's the court's issue with your motion to withdraw. How long have you been on this case?
Attorney of record was Anthony Wilson, Your Honor. I can't say exactly how many hearings he's had as the attorney of record.
Ms. Ferguson, when were they the attorney of record? All right, so we're going to start with what has been happening since you've been the attorney since March of 2024.
I was not the attorney of record, Your Honor.
Who was the attorney record?
Anthony O'Neill Wilson.
All right.
And he was the one that was hired, but he's with his law firm. Am I correct?
That's correct. He's in the same law firm. so-
All right. So we're doing word salad here, but that's okay. Let me divide this salad up. So April 1st, 2024, it was recalled for April 11th for a plea deadline date, and that was supposed to be the final plea deadline date. On April 11th, the plea deadline date was extended to April 15th because the defense counsel stated they were in Travis County. Even though Travis County starts with a T and not a B, that's where they were. April 15th, it was recalled to April 16th because defense attorney was no-show. April 16th, it was recalled to April 22nd, 2024 because the defense attorney was a no-show. On April 22nd, it was recalled for April 23rd for trial by Judge Angelini. Then on April 23rd, it was recalled again for April 24th by Judge Angelini for a jury trial. Then on July 9th, it was recalled for July 10th for jury trial. Then on July 15th, it was set for jury trial, September 9th, 2024 for impact court. Then on August 5th, it was set for a motion to withdraw by counsel and defense attorney was a no-show. Motion to withdraw is denied. Y'all need to be in impact for jury trial on September 9th. And they'll bring you over dressed for trial. They'll bring you over dressed in whatever clothing you have at the jail. If you wish to be attired in something different, then you'll need to make arrangements for your with your attorney to do a clothing exchange. If there is an issue with the clothing exchange, let the court know, and the court will see if I can help you with that expedited. All right, thank you.
And you know, if I may, as Anthony O'Neill Wilson is the attorney of record, no one other than him has access to discovery. He's poorly handled this case. There is no record of him actually ever downloading discovery. It's not like it's in the client's file. Since we are going to be held onto this case, I do ask that it be expedited to put me as attorney of record so I get access to discovery as soon as possible, as early as today.
Right, and my understanding is that your firm, he was with your firm, correct?
Yes.
All right, so Ms. Ferguson, just make sure that his name is there, but I will tell you, since your firm is listed as the firm, your firm should have access to the discovery. But if you're saying your firm doesn't, which I find that hard to believe since the previous attorney was a member of your firm, we will make sure that that happens. But a motion for continuance will not be granted because your firm is saying it does not have discovery when your firm should have discovery because you have a firm. The attorneys work underneath the umbrella of that firm and all that discovery should be there. All right, thank you. Is there anything else? Thank you.
Thank you.
Thank you. Good seeing you. All right, can I see Nathaniel Vasquez? If you'll come forward, please. Hello, Officer Mendez. Thank you so much for zooming in right away. You're on mute.
Good morning, Your Honor.
Good morning. So I have Nathaniel Vasquez here. I received the violation report from your office. He said he didn't have the proper contact numbers down. Is he able to report to you all today?
Yes, so he actually called me this morning and checked in with me via phone. So he has been checked in and he's currently back in compliance. The issue was the number that he had on file was his mother's phone number. And so every time that we would try to reach him, we were making contact with her, but we weren't able to make contact with him. And we would be told that he would make contact with us at later in the day whenever he would get home, but then we would never end up hearing from him.
So you have all of the appropriate numbers for him now?
He would make contact with us at later in the day whenever he would get home, but then we would never end up hearing from him.
So you have all of the appropriate numbers for him now?
Yes, as of this morning, he provided me with the 210.
Just 1 second. You don't need to say the number. So,
Okay, sorry.
But you've given her your proper number?
The one I called from this morning.
And that's the number where they can always reach you?
Oh, yeah.
All right, so you need to make sure you're there because otherwise they're going to send to the court another violation report and we're going to be having a different conversation. You understand?
Yes, ma'am.
And if there's an issue where you feel like you can't get in touch with them, I'm sure they'll provide an email for you to email them as well. You understand?
Yes, ma'am.
All right, does he need to see you today or no?
No, he's good. He's checked in today.
All right. All right, good luck to you.
Yeah, one
All
day.
right, you too. Just one second. Let me finish talking to you. All right, thank you, Officer Mendez.
Yeah, thank you, Your Honor. Have a good day.
All right, you too. All right, so here's the thing.
Yes, ma'am.
You can't wear that T-shirt to court, right?
Yes, ma'am.
Okay, so if you have another T-shirt, a black T-shirt would be fine. If you have a T-shirt with a collar, that would be fine. For dressing appropriately for court, I realize that not everybody has a three-piece suit with a tie that they can pull out. So all I ask is if you're coming to court, you can wear jeans if you want to. Just make sure they're not the fashionable jeans where people have the holes in them.
Definitely make sure.
And then you can just wear a t-shirt. If you want to wear a t-shirt, they used to call them polos for me back in the day with a collar. That's absolutely fine.
Yes, ma'am.
Okay. All right. Thank you.
Yes, ma'am.
Have
Have
a
a
good
wonderful
one.
day.
You too. Johnny Ruiz Jr. Who's the attorney on Johnny Ruiz Jr.? I think it's criminal trial division, collision involving death. All right. So I know there are probably still some outstanding discovery. Can someone tell me what's maybe outstanding? Do you have all of the medical? Do you have the autopsy?
I do, Judge.
All right. Is there anything that's outstanding?
Not that I'm aware of at this time.
All right, so this is what I'm going to do. This is a first setting case. I'm going to set it in 30 days for you to make sure that you have all of the discovery. And then on that day, if you have all the discovery, I'm going to want an acknowledgement of discovery.
Understood.
All right, Ms. Ferguson, I need a 30-day reset on Johnny Ruiz. State you're excused.
September 30th.
All right, we're going to come back on September 30th. All right, Mr. Ruiz, when you come back to court, no t-shirts, you understand?
Yes, I saw the last one. I do apologize. I'm nervous and I just wanted to feel comfortable.
Oh, no problem. Here's the thing, unless somebody tells you what you don't know it, right? And so I always tell people it doesn't have to be a three-piece suit, right? Because I don't have a three-piece suit hanging in the closet, although I would like one, but I don't have one hanging in the closet. So,
Understandable.
all right, so once you sign the reset form, you're excused. So what's going to happen? We're going to come back on September 30th.
Mhm.
On that date, your attorney is going to let me know if he has all of the discovery. If he doesn't, hypothetically, let's say he's missing a medical report. He'll let me know he's missing a medical report. Then we'll give a reset date for him to make sure he has that and the state turns it over. I want to make sure that he has all of the discovery so we can proceed.
Yes, ma'am.
All right. Do you have any questions about the process or anything?
Mhm.
All right, just take a seat. They're going to give you a reset form. And once you sign it, you're excused. And make sure you put your email if you have one on the reset form. Okay.
Yes, ma'am.
All right. Thank you.
Thank you.
David Vargas.
Morning, Judge.
Good morning. How's it going?
Great. How are you?
Oh, I'm doing okay. You know, Zach is leaving us.
You're leaving.
That's my last name.
Where are you going?
Going to intake.
I thought you meant leaving.
I'll wait to the front, sir.
All right. So we're back here. Today is the plea deadline date. It was previously reset so that the impact of any type of plea can be addressed by you.
Yes, ma'am.
So what is happening today?
Mr. Vargas is going to opt to go ahead and set up a trial.
All right. State, how long do you expect this trial to last?
More than 3 days.
All right, Ms. Ferguson. Can I have Vargas set for a jury trial? They say it's 3 days. It's family violence. Your plea deadline date has expired. The court will not accept any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. You understand?
Yes, Your Honor.
All right, and thank you so much. You always dress appropriately for court. I appreciate that.
October 14th, Judge, and it's going to be an impact.
All right, it's going to be October 14th, and it will be an impact court. All right, and can you all make sure that an acknowledgement of discovery has been signed and completed?
Absolutely, Judge. I'll double check right now.
We'll do it
All right.
this morning.
All right,
if it hasn't
thank
been done
you.
already.
All right, thank you. Thank you. Have a good day.
Thank you,
Just
Judge.
remain in the courtroom till you sign the reset form.
Yes, Your Honor.
All right.
Have a good holiday.
All right, you too. Ruben Sarna. And to think you almost were going to leave this case. See, attorneys do work hard. You understand?
Yes, ma'am.
And I still remember you maybe not wanting to speak to your attorney.
We got off on the bad foot.
Well, I mean, you got off on the bad.
I did, yes.
Yes. All right, so the state has filed a motion to dismiss for further investigation. What that means is maybe it's gonna come back, maybe not. I don't know. You understand? Defense, you have no objections to the court signing the dismissal?
No, you're not.
All right, you know what happened to cause you to be in this situation? Whatever happened, don't let it happen again. Because
ma'am.
this case, 5 to 99 years your life, okay?
Yes, ma'am.
All right, here you go, counsel.
Maybe excuse, Judge.
Yes.
Thank you.
Thank you.
Salinas?
Sarah Rodriguez. Sarah Elizabeth Rodriguez. All right, why were you late? I'm sorry, I cannot hear you.
There was a lot of traffic.
All right, you need to make sure you're on time. Do you understand?
Yes, ma'am. Can you step up to the mic?
All right, so we're here today for a contested hearing.
Yes, Your Honor, we need to set this for a contested hearing.
Oh, it is set today for a contested hearing.
Okay, Judge.
Okay.
Okay.
All right, thanks.
For what time, Judge?
Oh, now, whenever you all are ready to proceed. All right, just have a seat.
Thank you, Judge.
And when you're all ready to proceed, let me know.
Yes, sir.
Riot Aguilar. Hello.
Good morning.
Good morning. Why are you late for court?
I wasn't late, ma'am. I was here on time.
I'm sorry,
I
what?
was here on time.
Oh, I think you were. Just 1 second. No, you were on time. Somebody else wasn't here at 9. But that's okay. All right, so yeah, it's you. Me? Who, me? All right. So what are we here for today? Because it's been set.
If you get a trial setting.
All right, Ms. Ferguson, this is a 2-day trial. As previously announced, it's criminal trial division. And can you all make sure that you've done a discovery acknowledgement?
Yes, sure.
I think we already have, but I won't leave till we make sure.
Oh, you know what? You're correct. It was done on April 23rd. If y'all can make sure that there's been no further uploads since that time.
Judge, I'm just hitting all aces for you.
You're just hitting them.
I think the only.
Yeah.
Right.
Okay. And your client is dressed appropriately for court. It's like a stellar day.
I'm winning.
November 11th, Judge.
All right, we're going to come back on November 11th for your jury trial. All right.
Thank you, Judge.
Do you have any questions?
No, ma'am.
All right, once I'm asking him, I know you don't have any questions.
Judge, November 12th.
November 12th. All right, so do you have any questions? All right, we'll bring you back then. Once you sign the reset form, you are excused.
Thank you, Judge.
All right, you're welcome. Have a good one, guys. It is Friday Eve. I love Friday Eves. All right, could the parties approach on Sarah Rodriguez?
Yes, Your Honor.
And I'm assuming since the state has filed a motion to withdraw, the allegations in this MTR will not be brought up again?
That is not necessarily correct.
Then why are we doing a motion to withdraw?
We don't have a witnesses to present.
All right, so what I will tell everybody, and if I'm wrong in my thoughts on this, please let me know that I am wrong on my thoughts. I have no problem with people saying, I just don't think it's fair for motions to withdraw to be submitted or motions for or motions to be to dismiss to be submitted because we're not ready.
Judge, if there's any way that we can talk offline.
All right, who's here on Christian Chavez? I'm here. All right, so on this case, the last time we were here, there was a thumb drive that needed to be given so the medical records could be turned over. Has that been done?
I do not have a thumb drive, Your Honor.
We have the file, and I think that was one of the
Mhm.
So if he doesn't have that, but however, we have some other discovery. that
Okay.
He just brought to my attention today, Judge, so that can be, we can definitely get that done on the next one. There's all the body cams are here. We don't have the co-band. We have one co-band. There seems to be, I think it's been smart, but 18 different co-bands.
Okay.
But then, and we also have, let's see, security videos from possibly a Valera that we don't know if it's collector or not, because I can't detect them. So we're gonna be reaching out and we would resolve that by the next session.
Okay, how much time do y'all need, you think?
I would request 30 days on this one, Judge, because it's just for the fact of how much children, and then also.
I was gonna give you guys 45 days, but if it's 30, okay. All right, Ms. Ferguson on Chavez, could I have a 45-day reset for discovery? Thanks for dressing appropriately for court.
Thank you, Judge.
So I just want to make sure that your attorney has all of the discovery, okay?
Yes.
October 14th.
All right, we'll be back on October 14th for discovery. Is there anything else?
Nothing from defense, Your Honor.
All right, just have a seat. Once you sign the reset form, you're excused.
Thank you.
Thank you,
All right,
Judge.
you're welcome. Court is calling 2024 CR 008114, State of Texas versus Ashley Alexandra Hewitt. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Jose Rocha from Ms. Hewitt.
And are you Ms. Hewitt?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Why the heavy sigh?
Oh, just because, just to breathe.
Okay. Are you a US citizen? Yeah. I'm like-
Yes, ma'am.
According to the plea, there's a $600 fine. State recommends deferred adjudication. This is the run concurrent with 733622, and there's to be a drug court evaluation. Did you understand that to be the plea?
Yes.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There'll be a TAP evaluation, 120 hours of community service restitution, and no contact with Darlene Oliver. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor. Thank you.
When's the last time you were employed?
Last year.
All right, so last year. So what have you been doing with yourself? How have you been supporting yourself?
I get SSI
Why you're receiving SSI?
through my PTSD and schizophrenia.
If you're released, who would you be living with?
Just myself over across the street, over at Haven,
Where?
across the street at Haven.
Do you have any children?
I do, but they don't reside with me.
What are their ages?
24, 18, 15, 16 and 15.
And who do they live with?
My mother-in-law.
Your mother-in-law?
Mhm.
All right, how often have you been using drugs?
How often?
Yes.
Periodically, every other day.
And is it only the methamphetamine?
Mhm.
When did you start?
Back when I was 21.
Is there a reason you started? Do you know?
Just to cope. I was in a really abusive relationship.
Do you have any support system?
Mhm.
All right, and Miss Oliver, who is she to you?
She's my mother.
So it says here that you were yelling, saying that she owed you money. Why did you think she owed you
She
money?
didn't owe me money. I wasn't yelling at her.
I'm sorry, what?
I wasn't yelling at her. She didn't owe me money. I was telling her I was having a bad day because she told me to pick up the keys to the car. She was giving me her car. And she said to go ahead and go by over there to pick up the keys. And I was telling her about my bad day because I had lost a big old tote bag of like hygiene and stuff like that. And I guess like something clicked in her head or snapped or something because she has her own mental issues. And that's when she called her.
Okay. Court is going to sentence you to 4 years deferred adjudication. There's a $600 fine that will be probated. This is going to run concurrent with County Court Cause number 733622. There's to be no contact with Miss Oliver. If she wishes to have contact with you, then she can come in and let the court know. Otherwise, you can't go over there. So if she calls you and asks you to come over, you're not allowed to. So you're not allowed to contact her or go to that address. You understand?
I understand.
There's gonna be proof of SSI or employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 120 hours of community service restitution.
Then that's what the adjudication, right?
Yes.
Okay.
And and what I'm telling you, if you don't understand it, just stop me and let me know, okay? And probation is gonna go over conditions with you as well. If you don't understand something, let them know, okay? There's gonna be field visits one time per month for 3 months. Then at probation's discretion,
And that one time for 3 months, where is that at?
it's gonna be wherever you're staying.
Oh, okay.
I'm going to want in custody the following evaluations. There's going to be a MIC evaluation, felony drug court, and TAP. Felony drug court will be able, if they accept you in their program, they'll be able to help you with any type of mental health issues you have. They'll be able to help you with housing and everything. You understand?
Mhm.
And then if not accepted into felony drug court, then it's going to be lifetime recovery.
Okay.
Probation, is there anything else?
And how long is that drug court? for?
Just 1 second. All right. The felony drug court program is a minimum of 2 years. You understand?
Yes.
All right. Did you review the trial courts? All right, everyone, y'all are not reading that sign, and I know the staff is not helping you with that, but that sign says, do not approach while we're on the record, because I'm getting all this chatter over here, and when I have chatter over here, I can't 100% focus here. I'm at 98% instead of 100.
He wasn't talking to me, Judge. He was talking to Judge Lott.
All right, so other people,
I'm just saying.
here's the thing,
Sorry, Nick. I
Everyone.
apologize.
attorneys, stop approaching when we're on the record. Thank you. I don't know why Norma calling you out. She's done the same thing. I could name the other attorneys who've approached and the staff just chatting away. But all right, we can go off the record. Here's the thing. Everybody wants you to be successful. They think you can be successful. That's why they offered you deferred. That's why your attorney gave the offer to you, and that's why I'm accepting the offer. But in order to be successful in this court, you must communicate with probation. Do you understand?
Yes.
If you have an issue and you feel as though probation is not addressing it, you can always come back to court.
Okay.
All right, we're gonna go back on the record briefly. Bashan,
Yes, Judge.
instead of her doing the 120 hours community service hours, I'm gonna ask that you do sober support meetings. It's gonna be 120 and 120 days. In this court, I believe that community service hours, when you're helping yourself, you're helping the community. So instead of doing those community service hours, I want you to get into AA or NA meetings. You understand? All right. Thank you. All right, you're excused.
Thank you, Your Honor.
counsel. Everybody who wants to approach and talk to Norma now, do it.
I don't want to talk to you, Judge. I want to talk to the clerk or to Lott.
I'll talk to you.
I don't want to talk to her.
I was just gonna ask for that.
I wouldn't either.
See if you get called for the.
Yeah,
We'll be ready to proceed on the law needs. Oh, I didn't, you'd already been up here. I didn't know I had to go
Okay,
back
yeah,
over there.
let them know.
Apologize.
Oh, no problem. Rodriguez. Hello. So you all have submitted a motion to withdraw?
Yes, Your Honor.
Yes, Your Honor.
All right, and what conditions are you all asking to be added? Yes,
We're gonna ask for 90 sober support meetings in 90 days. DWI education. A TAP evaluation, follow the recommendations. Portable alcohol monitoring. And monthly UAs.
Yeah, we're in agreement.
are you all in agreement with that?
We are in agreement, Judge.
All right, we're gonna go on the record. Court is calling 2022 CR 10123, State of Texas versus Sarah Elizabeth Rodriguez. Can I have parties announced for the record for the state,
Andrew Harrison.
for the defense?
John Sanheiners for Miss Rodriguez.
And are you Miss Rodriguez?
Yes, ma'am.
All right, it's my understanding that the state is filing a motion to withdraw. The allegation in the motion that's related to this motion to withdraw, it's the court's understanding, if I'm incorrect, let me know, that that allegation will not be represented in another motion. Is that correct?
It is my understanding, Judge. However, my colleague from the state may answer.
Yes, Your Honor.
All right. So then in exchange, this is an agreement, and the agreement is to alter and amend your conditions of probation to 90 sober support meetings in 90 days, the DWI education course, a TAP evaluation that will be done out of custody, all of the TAP recommendations, the portable alcohol monitoring device, and monthly UAs. Do you understand that to be your agreement?
Yes, ma'am.
Are you asking the court to follow that agreement?
Yes, ma'am.
All right, then the court will sign the motion to withdraw, and we can go off the record. Probation is going to go over the new conditions with you. If there's an issue, you need to let them know. You're not allowed to drink alcohol while you're on probation. Do you understand?
Yes, ma'am.
All right. Thank you for dressing appropriately for court. Good luck to you. You're welcome.
Your Honor, I appreciate you. May we be excused?
Yes, but she'll need to talk to probation.
Yes.
Who's here on Watson? No applications, counsel? Court is calling 2024 CR 00808, State of Texas versus Jeremiah Levon Watson. Can I have parties announced for the record for the state? Defense?
Phyllis Beal.
And are you Mr. Watson?
Yes, ma'am.
Counsel, you received all of the discovery?
Yes.
Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
According to the plea, punishment is to be assessed at 100 days in the Bexar County Jail under 1244. Did you understand that to be the plea?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Yeah, Your Honor, the only thing I would like to say on behalf of him is that while he has been in jail for little, like, I think 103 days, he has completed all of these certificates, and he has also been attending sober meeting classes.
So, do you have a child?
Yes, ma'am.
And how old are you?
I'm 24.
And how old is your child?
He's 7 months. I got locked up when he was 6 days old. I've been dealing with the court for 7 months.
Well, I'm glad that you are taking advantage of the courses they have to offer at the jail. All right. Is Child Protective Services involved?
They came to the court, the jail, but I don't know now because I've been in jail.
Okay. Do you know who your CPS attorney is?
No, ma'am.
All right. So if they have a legal case, you need to know who your CPS attorney is. You understand?
Yes, ma'am.
And you need to remain in contact with them.
Yes, ma'am.
So you only have 1 child?
Yes, ma'am.
All right. Is there anything else, counsel?
Nothing else, Your Honor.
All right, the court will find you guilty, sentence you to 100 days in the Bexar County Jail under 1244. Court will show that the judgment is satisfied. All right, so we're going to go off the record. Here's the thing. You brought a baby into this world. You've got to be the type of person that your child would be proud to say, that's my dad. You started off badly because now you have a felony conviction, but it's not too late for you to turn things around. So you need to start working on yourself. All right. And take parenting classes again, because one thing I know about babies is you have to have patience. You understand?
Yes, ma'am.
And you got to give them an environment where they feel comfortable telling you their feelings and where they can grow.
Yes, ma'am.
All right. Do you have any questions about anything?
Am I getting out today?
You have other cases that are misdemeanor cases, so I don't know what's happening on your misdemeanor cases, so you'll need to address that with them.
Yes, ma'am.
But what I can tell you, if you have any issues with finding parenting classes, if you feel as though you're going to use drugs again, even though you're no longer out of this court, if that's happening and the misdemeanor court is not able to address that with you, you can always come back to me. I will pick up the phone, call somebody to put you in the right path, because the last thing we need is another baby who is not having a good relationship with their father, because they may end up before me. You understand?
Yes, ma'am.
All right. Good luck to you. Thank you, Miss Bell. Bill, always good seeing you.
Good to see you.
Have you been snorkeling of late?
I actually was in Costa Rica recently
Ah,
on the
okay.
Pacific side.
I haven't been to Costa Rica yet.
It's very fun. The mountains are very high.
Mhm.
Pretty nice.
All right. Awesome.
Jeremiah.
Alfonso Sosa, are you all ready to proceed?
Yes, sir.
Court is calling 2015 CR 9437, State of Texas versus Alfonso Sosa. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Nathaniel Navy for Mr. Sosa.
And are you Mr. Sosa?
Yes.
All right. Did you review the motion to revoke with your attorney? Did you understand it?
Yes.
Are you the same Alfonso Sosa who was placed on community supervision in 2015 CR 9437 for the offense of assault, family second offense on May 21st, 2019 for a term of 6 years? Is that you?
That's me.
All right, state.
Violation of condition number 5. In Bexar County, Texas, the defendant, Alfonso Sosa, did then and there fail to report to the supervision officer and in person or through virtual means for the months of August 2020 in violation of condition number 5.
How do you plead to that? True or not true?
Sure. Your Honor, the state will waive and abandon the others.
Any objections?
No, Your Honor.
Did you understand by pleading to violation of condition number 5, the court could find it true, grant the motion? All right, we need to go back on the record. I'm sorry, we're still on the record, but we need to go over this again, because this says motion to revoke, but I'm looking at the judgment and it shows that you're on deferred adjudication. So, yes.
And I just have something to add to that, Judge. He had a motion to enter an adjudication of guilt in 2019.
Mhm.
The state and I were a little bit confused on that as well, because then the judgment said that he was sentenced to 6 years. There's a little tiny box on there that said sentence suspended and
Yes.
probated for 6 years. So I thought it was incorrect as well at first, but then I went through the court's file and I saw that. So I think it is correct. He was just, he was found guilty in 2019, and now he's back on a motion to revoke the probation.
All right, thank you. So did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, and sentence you up to 6 years in prison? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor,
Yes.
for 2 years TDC.
All right. So what has he done on probation? Has he done anything?
So there was in the beginning, hold on, I'm flipping back, Judge. I think there was a completion of safety. And that was back in 2020. And then there was a CAP completed back in 19. And then, as of course, the court knows, this MTR actually originates, even though the state waived and abandoned the other conditions, all 3 of them are over 4 years old, those violations in August 2020. So that is the knowledge that the state has with respect to a court summary of what this individual has done.
Defense?
Yes, Judge, I'd like to provide a little bit of context and hopefully some mitigating circumstances for the court to consider. Mr. Sosa is homeless. He was ordered to complete the SafeP program. From my understanding, he was transferred to Austin, and that's where he completed it. He did the aftercare program there. He was released, and he asked, I don't know who he asked, if it was somebody with the program or somebody with probation, about getting back to San Antonio. He was told that, that's everybody has to organize that on their own. And so, because he was wondering about a bus ticket or something like that, he's homeless, completely indigent. And he actually, I believe, remained in Austin from when he was released all the way until when he was picked up, because I think he was arrested there and actually extradited here from Austin. So when he was released, he just remained in Austin. So due to those hardships, he kind of remained there, Judge. It wasn't a situation where all he had to do was, go somewhere and he had access to it.
All right, because this is Judge Hall's writing probation.
Yes, Judge.
So is this true that if you're transferred to Safety in Austin, they do not provide transportation back once you've completed it?
Judge, that's something I'd have to look into. If you give me just like 2 minutes, I can find out.
Sure. All right, so if you all will step back.
Okay, Judge.
All right, are you all ready on Carly Green? All right, so what is happening with Green?
So we were,
Where's, come forward, Ms. Green?
so we were here, I think on Monday or Tuesday. We got recalled to today because the state was trying to reach their witness. I believe they did, well, I don't want to speak for them, but they reached the witness. I know she's opposed to it, but I'll let them speak to that.
All right. All right, we're going to go on the record in 2023 CR 10223, State of Texas versus Carly Green. Can I have parties announced for the record for the state, for the defense?
Adam LaHood for the defendant.
And are you Miss Green?
Yes, ma'am.
All right, this is a continuation of a previous hearing, and it's in regards to the motion to modify bond conditions. Defense is asking for GPS to be removed.
That's correct, Your Honor.
All right, state, you're going to speak to the complainant. So here's the issue. The issue is, I don't know anything about this case other than she's charged with aggravated kidnapping. So I'm assuming the aggravated kidnapping is the complainant that you've spoken to. All right. So does anyone want to give me what they think? Well, let me strike that. So it's aggravated. There are different ways that it can be aggravated. So what's alleged to have made this aggravated?
They're alleging the presence of a firearm in the indictment.
All right. And allegedly, what is her relationship to the complainant, if there is one?
Acquaintance at best, friend kind of at a mutual get together.
Okay, so here,
Best phrase, Your Honor, would be social acquaintance.
There you go.
so here's the court's other question. She's on tracking, correct?
Yes, Judge. She's allowed to go to the grocery store, but otherwise she's, are you working? Yeah.
So here's the question then. Would there be an issue if she's just on tracking, period?
No.
No, not from you.
Sorry.
I know you,
Okay.
you don't. State, do you have any issue with her just being on tracking? Because then the complainant will know where she is. At least the state will know where she is. But would parties agree, doesn't tracking take care of whether or not she's had contact with the complainant? If you all want to put in the court's order, I'm going to do tracking only. The last hearing we had, she's been on GPS for a long time now. I will do tracking only. State, if you have a location area that you do not want her to be in, if you all can agree on what that location is, then I can include that as an exclusion zone.
Perfect.
All right, so I am going to deny removal.
Okay.
It will be tracking only with an exclusion zone. So if you all will write in here, the exclusion zone for the court.
Yes, ma'am.
Is there anything else?
Nothing from the defense.
Okay.
Thank you.
So if you'll write that in here.
Thanks.
Thank you.
Thank you.
Bashan, are you ready on Sosa?
Yes, Judge.
All right, we're back on the record in 2015 CR 9437, Alfonso Sosa. Miss Abrams, what did you discover?
So, Judge, typically it would be the responsibility for the defendant to find his way home after the Austin Transitional Center releases them. However, we try to work, they have the ability to work to get the funds. They work closely with them to get the funds to be transferred back. Back in 2020, the staff that we have currently was not managing that unit. So things have changed. Just so that we're fully aware, what happens now is they work hand in hand with nonprofit organizations to get the funds to get the defendants back to where they came from.
Okay.
So at that time, that may or may not have happened. We don't have record of that. But to answer the court's question, it is the responsibility of the defendant once they are released from the transitional center to go back to where they reside.
Okay. All right, thank you. Mr. Sosa, are you asking the court to follow this agreement that's been reached?
Yes,
Are you waiving your right to appeal?
yes.
All right, the court will follow your agreement. The court is finding violation of condition number 5 true. There's an affirmative finding of family violence, 2 years in the prison. Give you credit for any time served, and I'll give you credit for time in inpatient treatment that was successfully completed.
Thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it?
yes,
And did you sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
yes.
All right, do you have any questions about anything? All right, we can go off the record. I'm sorry that at that time they were doing things where they place you in a completely different location and expect someone who's homeless or who's recently released from inpatient treatment, which you have no money because you're in inpatient treatment, for them to expect you to make it back here on your own. All right, good luck to you.
Thank you. Good luck.